of a determination arising out of a vote. Is it the sort of review that is contemplated in these proceedings? I say, or I add one point to that, that because the members of the National Assembly, the members of Senate, are not required under Article 1, Subarticle 2, to give the reasons as to why they voted however they voted, what would be this reason that would be testing if we were to apply a test, for instance, of Wensbury unreasonableness under the Mushemi to make his presentation. I'm most obliged.
Very briefly, my lords, since the Parliament has only met the threshold of 2/3 majority on any bill or any motion on 2 occasions. The first of these occasions was during the passing of the BBI bill, the now defunct bill, where on the 7th of May 2021, the National Assembly approved that bill with 224 members in support and 63 voting against. And in the Senate, on the 11th of May 2021, with the bill being passed by 51 members, 11 voting against and 1 abstention. My lords and my lady, my client, the 9th respondent, brought this motion pursuant to Article 145(3) and in historic numbers, first as required by the Constitution to garner 117 signatures, he was able to garner 290 signatures of members of the National Assembly to present this motion. And when the motion was tabled on the 27th of September 2024 and subsequently debated on the 8th of October 2024, as has been submitted by my learned colleague Mr. Gumbo, the motion was supported by 282 members, representing 80% of the whole House. This was not just a majority, but a supermajority. When the motion went to the Senate and the vote was taken, and I'll only rely on one ground number one, 54 members voted for the motion, 12 against, and 1 abstention. My lords, you have been told that Parliament acted as a lynch mob, but there has never been occasion in the 16 years that this constitution has existed that Parliament has voted on such numbers. If that were the case, you would have been given instances or other examples where Parliament has acted in this manner. And the reason these numbers were achieved, supermajority in both houses, and you see that they exceed the BBI numbers. In fact, in the National Assembly, they exceed by almost 60 members of the National Assembly, is because of the weight of the 11 grounds of impeachment. My lords, it is our submission that in our country, there is no country anywhere in the world with a higher threshold of impeaching a president or deputy president in this case than this country. If you go to the United States, for example, in the House of Representatives, which is the lower house, you only require a simple majority to approve the articles of impeachment. It is in the Senate that you thereafter require 2/3. If you go to the Philippines, and here we are comparing presidential systems, you require 1/3 of all the House members to endorse the complaints and 2/3 of the Senate. Nigeria has a system such as ours, and so does Brazil. So it is our submission that the safeguards provided by our Constitution are adequate to ensure that this process is not abused. Our Constitution further requires public participation, and this requirement now sets it apart from those examples that I have given you, where impeachment is handled solely by elected representatives. And as will be submitted by my colleagues, public participation was conducted across all constituencies in Kenya throughout this process. So in fact, my lords, we have no comparative in the world. We have the most progressive and advanced constitution in the world when it comes to impeachment of the president. The argument by the petitioners that either Parliament acted as a lynch mob is again not true. The argument that the deputy president was elected by the people, whereas is true, the contra-argument is that he was also sponsored by a political party to run for office. He ran for office as deputy president under the banner of a party called the United Democratic Alliance, UDA. And my lords, under Article 38 and under Article 91, political parties are the foundation of our constitutional democracy. In the National Assembly, at the time the deputy president was being impeached, the UDA had 144 members of the National Assembly. Out of those, 114 voted to impeach the deputy president, with 21 voting against. And it is our submission that it is clear that he had lost the confidence of his own political party to continue holding office. Our colleagues have cited numerous authorities from South Africa, and South Africa is a good example of how leaders respect decisions of political parties. President Mbeki in 2008 resigned after he was recalled by his own political party. He was not heard by the party. He was not invited to any hearing. The party just met and said they had lost confidence in him. This decision was submitted to him, and he said that he respects the decision of the party, and he resigned. The same thing happened to President Zuma, who resigned on Valentine's Day of 2018. And the following day, President Ramaphosa was sworn in. The party simply said, "We have lost confidence in you." Closer home here in Zimbabwe, when President Mugabe was removed as leader of ZANU-PF on the 19th of November 2017, again he opted to resign because he was going to face an impeachment vote. Parliament is often considered the highest form of representation in a democracy because it serves as a primary venue where elected members represent the diversity, will, and sovereignty of the people. It is our submission, Your Lordship, that the first petitioner not only lost the confidence of Parliament, but he had lost the confidence of the political party that sponsored him to run for political office. My Lords, you have been told a lot about the grounds of impeachment. And in Article 145, the framers of our Constitution and the context of our Constitution has to be read in its plain text. They gave 3 grounds for impeachment, and they said gross violation of a provision of this Constitution, and where there are serious threats of believing that the President has committed a crime, and for gross misconduct. There was very good reason for the drafters to give these 3 reasons, because they were not to subject the President or the Deputy President to judicial standards by members of Parliament. They were not to subject them to judicial standards. The charges against the Deputy President, 11 of them, are not to be subjected to judicial standards. I know my colleagues will give you examples of how other presidents have been impeached. But presidents all over the world have been impeached for far lesser crimes, for far lesser transgressions than you have seen here in our country. Here the impeachment was on serious violations of the Constitution. I'll go to the grounds of the impeachment, my Lords. And you are told about subsidiarity. Ground number 6 of the impeachment, where the Deputy President was accused of crimes under the National Cohesion and Integration Act. Ground number 7, where he was charged with the economic crimes under the Anti-Corruption and Economic Crimes Act and the Proceeds of Crime and Anti-Money Laundering Act. And ground number 8, where he was charged with contravention of Section 29 of the Leadership and Integrity Act. you have been told that there should have been deference by the National Assembly to the institutions, that is NCIC, EACC, and the DCI, to allow them to investigate those crimes before Parliament could do the duty that they did. That is not true, and we are guided by a decision of this court by a 5-judge bench in petition number 295 of 2018, Philomena Mbete Mwilu versus DPP and others. This was a 5-judge bench, Justice Omondi, Justice Ngugi, Justice Tuyot, Justice Musyoka, and Justice Muita, delivered in 2019. And in this decision, particularly paragraph 379 of that decision, the judges go on to say, and this was a decision which the Deputy Chief Justice had challenged charges that had been preferred upon her by the DPP in the Chief Magistrate's Court. And the judges say that from the analysis, the following principles emerge. First, in the absence of an express statutory or regulatory provision requiring prior approval or sanction from another authority in order to prosecute a judge or judicial officer will face trial directly in the event that he or she is alleged to have committed an offense. However, and this is the second principle, where there is a specific legal framework for dealing with misconduct and or removal of judges, cases involving misconduct with a criminal element committed in the course of official judicial function or so closely proximate or linked to the judicial officer must first be referred to the body responsible and the disciplinary or removal process commenced. My Lord, it is our argument that this decision applies in this case. And the holding, in fact, was that while the DCI is not precluded from investigating criminal misconduct of judges, there is a specific constitutional and legal framework for dealing with misconduct and removal of judges. Consequently, cases of misconduct with a criminal element committed in the course of official judicial functions or which are so inextricably connected with the office or status of a judge shall be referred to the Judicial Service Commission in the first instance. Your Lordships, it is our argument that this applies even to the office of the President and the Deputy President, that where there is already a mechanism of disciplining them, then that mechanism ought to be exhausted first and not the other way around. In fact, our Constitution does not contemplate a situation where the President or the Deputy President would be facing organs of security which are appointed themselves by the President. And that is why the Constitution then provides this mechanism in Article 145 to discipline the President and the Deputy President and to hold them account through their removal by Parliament. This position was supported by several other authorities, and there is an article I will urge you to read, The Temporary Criminal Immunity for Federal Judges, that is contained in that authority. Secondly, Your Lordship, the petitioners argued, particularly in relation to ground number 9, that the National Intelligence Service ought to be under a civilian supervision. And whereas that is true, Article 239 provides that it is one of the national security organs, the other two being the KDF and the National Police Service. And in fact, in the composition of the National Security Council, and there are 9 people who sit in that council, it is only the Deputy President who is not appointed by the President, meaning that the Deputy President is very central to the running of that council. Your Lordship, it is our submission on the issue of fair hearing that the Deputy President in the National Assembly, and Mr. Gumbo has taken you through this, was present. He was represented by legal counsel. And I think the place you need to dwell on most is the Senate. It is my client's case that, in fact, prejudice in the Senate was suffered by the 9th respondent and the National Assembly. And why do I say this? This is because the first petitioner was able to present his case and his documents. He was able, through counsel, to cross-examine witnesses of the National Assembly, including the 9th respondent. But when the time came to cross-examine him, he was not available. So the prejudice was not on him, because his evidence was treated without any cross-examination. And you see the result of the Senate, that in fact 6 of the grounds that the 9th respondent had presented through the National Assembly were not confirmed by the Senate. And the reason they were not confirmed was because the Deputy President was not cross-examined. Nevertheless, of course, any of the grounds is enough to seal his fate. But there was serious prejudice, not by the Deputy President, but by the National Assembly. On the issue of the committee route and the plenary route, our submission is that the plenary affords the whole House, and indeed the Deputy President, an opportunity to interact with the entire House, as opposed to the committee route, which limits the numbers. And remember, Your Lordships, the committee route is decided by the leadership of the Houses. So if the leadership of the Houses, the majority and minority, are working together, then they are likely to conspire to form a partisan committee. And therefore, actually, the first petitioner should be supporting a plenary route, which then exposes him to the entire House, so that he is able to convince each one of them individually on the hearing. And that is why Senate, in its wisdom, elected to follow this route. My Lords, you are taken by my learned senior Githu Muigai on Wambora and Sonko, and we rely on those decisions. But I want to mention briefly that there are 2 decisions that my learned senior Mr. Kibe Mungai talked about this morning. And one was just delivered last week regarding President Ramaphosa in South Africa. And there was a decision that preceded that one, EFF2, which then directed the Parliament in South Africa to constitute rules to be able to conduct impeachment processes. And those are two very progressive decisions. I thank Mr. Kibe for bringing them to the attention of this court. But the reason they are not applicable to our situation is because South Africa has only one chamber. We have two chambers here. We have the National Assembly, which acts the way the South African Parliament does, but we have a Senate to conduct the trial. So that decision is relevant to South Africa because they only have one chamber. And what the Constitutional Court was saying in EFF2 is that you need to formulate rules to be able to conduct impeachment. In this EFF3, which has been attached, the Constitutional Court is now saying that the independent panel report that was voted out by Parliament ought not to have been voted out, but taken to the impeachment panel. And that is precisely what our Kenyan system is, that you've had in the National Assembly, but you go for a trial in the Senate. That is the distinction between ourselves and South Africa. Your Lordship, on the issue of decisional independence of the judiciary, you have been told by the petitioners that that there was indeed a complaint filed in the Judicial Service Commission by the first petitioner, whereas that may be correct. If you look at the decision of Apple Omboya versus Judicial Service Commission, petition number 204 and 218 of 2016, a decision by your brother Justice Korir, as he then was, this decision has talked very well about decisional independence of the judiciary, and if you get time to read it, you see that despite the first petitioner having filed a complaint in the Judicial Service Commission, it still did not warrant that he continues making attacks on the judiciary and the judicial officer in question. And that is covered very well in that decision. Therefore, your Lordships and my lady, that is the humble submission of the 9th respondent. We urge you to dismiss the consolidated petitions. Thank you.
My lords, my lady, if it may please in the matter, my name is Milimo. I appear, my lord, for the first respondent, as well as the 8th respondent, the Speaker, and the Deputy Speaker of the National Assembly. My lord, my lady, I will be very brief. The first ground that I wanted to handle is a complaint against the Speaker that the proceedings were fast-tracked. And on that, I associate myself with the submissions of my learned colleague, Mr. Gumbo, that what the Speaker of the National Assembly did was simply to comply with the rules that had timelines, and that compliance does not amount to expeditious or fast-tracked disposal of the proceedings. And my lord, my lady, we rely on the grounds of opposition that are dated 18th of October 2024, and the submissions that are dated the 20th of April 2026. My Lord, my lady, I'm only left with one issue, which was alleged by the petitioners, that generally the Speaker was biased against the first petitioner. And I will demonstrate, my Lord, that that allegation is indeed untrue and incorrect for the following reasons. Firstly, Lord, you shall note that the Speaker of the National Assembly does not participate in the proceedings of the House. The Speaker is merely a presiding officer of the House. And my Lord, that is the dictate of the Constitution under Articles 97 1D and 107 1A of our Constitution. My Lord, the views of the Speaker presiding over the House does not matter and has no influence to the proceedings in the House. And of importance, my Lord, is that, as you've been told by my learned colleagues, impeachment proceedings are determined by a vote. And that vote is by members of Parliament. The Speaker of the National Assembly, at no point in time did he vote in these proceedings. In presiding over the House, my Lord, my lady, the Speaker was undertaking a constitutional duty as prescribed by the Constitution. And under the standing orders of the National Assembly, the Speaker is expressly prohibited from voting. And although my learned senior, Paul Muito, been a former member of Parliament, knows this, but just for the record, allow me to refer the standing order that so states that position, and that is Standing Order 69 of the National Assembly. And allow me to read, my Lord. It states, that is Standing Order 69.1, states that unless otherwise provided under the Constitution, a question arising in the House shall be decided by a majority of the members in the House present and voting. Then 3 says, on a question proposed for a decision in the House, the Speaker has no vote. The Speaker, therefore, does not participate in the decision making. And in this case, my lady, it was unfair for the petitioners to complain against the Speaker presiding over the House. The second point, and there was an allegation that the Speaker was biased because he's a member of the Kenya Kwanza coalition, and that by virtue of that association, therefore, he ought not have presided over the House. My lady, my lords, you shall note that the mover of the motion presented the motion as an individual member of Parliament. The motion was never presented by the Kenya Kwanza coalition. And it did not matter, therefore, that any member of the House was associated with any coalition in the House. And more importantly, my Lord, my lady, the first petitioner himself is a member, or was a member, of the Kenya Kwanza coalition. And if there was any favor then that would emanate from association, then he ought to have been a beneficiary. The association of either party to the coalition, my Lord, my lady, you shall note that did not have any impact, as the voting was across the board, both by the members of the Kenya Kwanza coalition as well as the Azimio coalition. So association, therefore, did not matter. But more importantly, the mere fact that the Speaker of the National Assembly is associated with a coalition in the House is not unique. And that in itself does not amount to a biased presiding officer. And I'll give examples, my lord, my lady. In Tanzania, the Speaker of the Assembly is also a member of Parliament elected in a constituency. In Uganda, the same position applies. The Speaker of Parliament is also an elected member of Parliament. Again, in South Africa, my lord, the member of Parliament is elected as a Speaker of the National Assembly. And that applies everywhere, including even in the Kenyan Senate. The Speaker of the Senate is associated with a political coalition. And therefore, it's not unique for the Speaker of the National Assembly to be or to have association with a political party. He enjoys his right to participate or associate with a political party. The third allegation, or rather the allegation also about him being a biased presiding officer, you shall note that that allegation was never raised when the impeachment proceedings were presented before the House. That issue only arose when the pleadings were filed before this court. Yet, we've been told here that the first petitioner was represented or was accompanied by a battery of lawyers who appeared with him before the House. The raising of this issue, therefore, before you, my lady, my lords, is an afterthought. It's just for the mere so, but without any consequences. The other point I wish to raise on that, my lords, my lady, is that the Speaker of the National Assembly never commented on matters relating to the impeachment proceedings before or during the impeachment proceedings. He never made any comment whatsoever. His position was and still remains that he had no fight, he had no dog in the fight. He had absolutely no interest in the impeachment proceedings, and it's therefore unfair for the petitioners to complain for him merely having discharged his duty to sit as a presiding officer. The other complaint or issue that was raised about his biasness was in reference to a constitutional petition that I argued with my learned colleague Kibe, petition E202 of 2023, my lords, that had stated that the Speaker ought not be a leader of a political party. My lord, my lady, you shall note that that was not the ratio of that judgment. It was indeed an obiter, as it never formed part of the findings of that decision. But more importantly, the petitioners in that case had sought expressly that the Speaker be barred from presiding over the proceedings of the National Assembly, and that he again be removed as a Speaker of the National Assembly. All those prayers were dismissed by that court. None of them were granted. And in that decision, the Speaker of the National Assembly was never stopped from presiding over the proceedings of the House. And it therefore cannot be invoked as a decision to show that there was bias on the part of the Speaker of the National Assembly. Just to add, my lords, my lady, is that there's an appeal pending against that decision in the Court of Appeal, and we will be sorting ourselves out on that matter. The other point, my lady, that was against the Deputy Speaker, you shall note that the Deputy Speaker at no point in time did she preside over the proceedings relating to this impeachment. She never sat as a presiding officer. Her decision in respect of this matter was made through a vote that she was entitled to do as a member of Parliament. Her views, therefore, whether for or against the impeachment proceedings elsewhere, could not have an impact in the decision that was taken by the House. And more importantly, my Lord, my Lady, is that none of the members of Parliament complained that the views of the Deputy Speaker influenced the decision that was made by way of voting. Another point that I would invite the court to consider is that there's no prayer in the entire petitions that has been sought against the Speaker and the Deputy Speaker. Their involvement in these proceedings was for the mere so. And if it were that then the petitioners were true, that they had an issue with the Speaker and the Deputy Speaker, they ought to have sought a prayer against them. There's none whatsoever before you. What the petitioners are doing, my Lord, my Lady, is that they are shooting in the dark with a name that somehow they'll hit the target. Unfortunately, the Speaker and the Deputy Speaker cannot be a target in these proceedings because they had no fight. There's no dog in the fight. My Lord, lastly, you realize that these are the same petitioners that had filed recusal applications against this court. And indeed, they had raised issues of bias.
What's the relevance of that line of argument?
I wish my line colleague would have waited so that I showed the relevance. My Lord, that is a decision which is part of the record, and I don't need to cite it.
Sure.
All I was saying, my Lord, my Lady, is that the standards of recusal have already been established by this court in its recusal application and upheld by the Court of Appeal. And that the mere mention of the word bias, a four-letter word, and association by a party does not in itself constitute a reason to ask a presiding officer to recuse him or herself. And that does same reasoning, my lords, my lady, ought to apply here. And we seek that you find the allegations that have been laid against the Speaker and the Deputy Speaker to be without a basis, and they'd be dismissed. We associate ourselves with the submissions of our learned colleague for the respondents and the AG seeking that the petition be found without merit and that it be dismissed. That will be all, my lord, my ladies. I thank you.
Not yet, my lord. For the National Assembly.
What's the name?
Very well, my lord. My name is Elias Ouma. I'll address you on two straightforward issues, namely, whether the sub judice rule under Standing Orders 89 of the National Assembly and Standing Orders 103 of the Senate could be interpreted to bar parliamentary proceedings on impeachment where judicial proceedings are still pending. My lord, from the very outset, it's our firm position that this court could not and should not interpret Standing Orders 89 of the National Assembly and 103 of the Senate to bar the National Assembly from deliberating impeachment proceedings in the disguise of sub judice rule. My lord, we take this position based on three arguments. First, the very standing orders is not absolute rule. The very standing orders that provide for sub judice is not absolute. Neither is it automatic. My lords, my lady, the standing orders establishes a two-limbed threshold which must be satisfied conjunctively for the same to be invoked. My lord, for clarity, permit me to read Standing Order 89, 1 and 2 of the National Assembly, which is pari materia with Standing Order 103 of the Senate Standing Orders. My lady, my lord, under 89.1, the sub judice rule is established. More critical to note is its applicability and its definition under 892. It says, a matter shall be considered to be sub judice when it refers to active criminal or civil proceeding and the discussion of such matter is likely to prejudice its fair determination. My lord, from that text, the word "and" is carefully crafted. It is deliberate and restrictive. It provides a mandatory conjunctive element that for the preceding statement to ensue, then the petitioners ought to have established a level of prejudice. My lord, why do we say so? The Court of Appeal, and this is a decision we have cited in our supplementary list and digest of authorities, in Korir versus Republic, Criminal Appeal number E52 of 2023, had a chance to define the meaning of the word "and" when used in a statute. My lord, if you go through that decision, you will note, and with reference to this standing order, that for sub judice rule under 89 to be invoked, there must exist an active proceedings before a court of competent jurisdiction. Secondly, and more critically, there has to be a demonstrable likelihood of prejudice. Who then has the burden of proving this prejudice? And that takes me to my second argument. My lords, my lady, it's our submission that the petitioners at the time of trial in the Senate and the National Assembly had the burden of providing, by way of evidence or demonstration or through a preliminary objection at the National Assembly at a preliminary stage, the level of prejudice to demonstrate that the discussions and the debate on impeachment could actually impair administration of justice in the impending cases. Worth noting, my lords, my lady, in your previous ruling, this very bench provided the remit within which this court can intervene during impeachment. Those decisions are your decisions. And that's the reason why this issue was not raised in the National Assembly. And to my third and last argument on this issue, my lords, before that, my lords, it's important to note for clarity that a cursory glance of the Hansard, and that is marked SN13 in our affidavit by Samuel Njoroge, that issue was never raised. It was not raised. And to my last argument on this issue, it's our submission that standing orders ought to be interpreted purposively and in a manner that gives full effect to parliamentary autonomy and the constitutional doctrine of separation of powers.
as submitted by my learned senior and pupil master, Mr. Eric Gumbo, under Article 95(5) of the Constitution of Kenya, it is the National Assembly, not courts, not executive, not commissions, that has the mandate of initiating the process of impeaching the Deputy President. What does that mean, my lords, my lady? Under the doctrine of separation of powers, the rubrics of doctrine of separation of powers, and this has been cited in our list and digest, the Supreme Court in Mate, Justice Kariuki Mate and another, versus Martin Nyaga Wambora and another, 2017 EKLR, at paragraph 63. The court set the parameters within which various state organs must function. It provided 5, but of critical is number 3. The court said that each arm of government is under duty to refrain from directing or interfering with another organ on how to exercise its mandate. To the extent that the issue of impeachment and initiation thereof is a preserve of the National Assembly, then this court should not be invited, in disguise of sub judice rule, to interfere with the functions of the National Assembly. My Lord, any contra-interpretation would allow litigants in future to weaponize the judiciary to protect public officers who should be accountable as submitted by my pupil master and who should be held accountable under Article 145 of the Constitution. Because of time, my lord, my lady, I'll take you through the second issue, which is also rather straightforward and raised by one of the petitioners. That is whether the participation of Honorable James Orengo Senior Counsel as sitting governor and Honorable Tienda Amolo Senior Counsel as member of the National Assembly created a conflict of interest and undermined the fairness of the impeachment proceedings. My lords, my lady, first, it's our submission that there is no constitutional or statutory bar that will prevent an otherwise qualified advocate to represent a party either in court, tribunals, or quasi-judicial commissions. The only exemption that exists is where there are conflict. As submitted by Manad Senior, conflict requires evidence. Conflict must be demonstrated. It's our submission that the petition has failed to demonstrate by way of evidence that the participation of Honorable Orengo and Honorable Tienda Amolo would prejudice and or result to an impaired proceedings during impeachment. More important to note is that this very issue has been determined by a court of equal status in John Okello Nagafwa versus Independent Electoral and Boundary Commission, 2013 EKLR. What did the court say, my lord? The very subject individual was subject of that petition, that is Honorable Orengo. At paragraph 27, this is what the court said. The petitioner has not demonstrated before this court that Orengo has used public time in preparing for and participating in this election petition. No evidence has been shown to the court to demonstrate that council's conduct this far is inherently incompatible or fundamentally in conflict with this role as a member of Senate. My Lord, it is the petitioner's contention that the participation of these state officers contravened Article 77 of the Constitution. What does Article 77 of the Constitution say, my Lord, my lady? Article 77(1) says that a full-time state officer shall not participate in any other gainful employment. My Lord, to give effect to this provision, Parliament enacted Leadership and Integrity Act. That act was repealed, but it was in operation at the time of impeachment of one Rigathi Gachagua. My lords, my lady, under section 26 of that act, there is a definition of a gainful employment, and for that provision to apply, there's a condition that must be demonstrated by the petitioners. And that is section 29(2). It defines gainful employment to mean work that a person can pursue and perform for money or other form of compensation or remuneration. And this is where it's important to note, which is inherently incompatible with the responsibilities of the state office or which results in impairment of the judgment of the state office. The petitioners are saying that the participation of Honorable Orengo resulted to gainful employment. But they have not given you any evidence to show how it impaired the judgment of these state officers. My lords, my lady, it is the rule of the thumb that he who alleges must prove. All the petitioners are saying are speculations, and they are not anchored on any basis. On that ground, we urge you to dismiss their issues as raised in their petitions. I'm most obliged, my lady.
I think before you sit down, the citation you were given about Senator Orengo, I think you picked and chose what you wanted. There are better opportunities on that issue.
Yes, my lord.
Look at the case of Manduku of CPP. I did it myself and I made comments on that. I think you owe it to the court. Although we are not bound by our decisions, you should be candid enough to say that there's also another case where the same issues arose, and this is what the court said.
Yes, my lord. Just to distinguish that, my lord.
Why did you not say anything about it?
I'm much obliged, my lord.
Just sit down here. Okay, you are finished.
Most obliged, my lord. Most obliged.
It's 2 o'clock. I think we should take a rest and then come back at 3.
Nairobi, where the hustle never sleeps and neither do the scammers.
Link up, we are talking about something that's affecting all of us. We are talking trust.
We're diving into the campus life.
Stay fresh, stay safe.
Stay linked up.
Sundays at 8:30 p.m.